my name is Victoria Ogunsanya. I'm from the Lawyers Committee for Better Housing. Our guest today is Ray Carizzi, the Mediation Services Director at the Center for Conflict Resolution. I'd like to let you know that our upcoming episodes are November 1st, Keep Chicago Renting Ordinance. We'll be with the Albany Park Neighborhood Council. On November 8th, we'll be discussing building conditions with the Metropolitan Tenants Organization. November 15th, we'll be discussing healthy homes also with the Metropolitan Tenants Organization. Also tomorrow, the Rental Housing Expo will be at Loyola University, 1125 West Loyola. So let's get to it. So Ms. Ray, can you tell us a little bit about the Center for Conflict and Resolution?
Yeah, so the Center for Conflict Resolution is a nonprofit organization located in downtown Chicago that provides free mediation services to all people. It was started in 1979. By the Young Lawyers section of the Chicago Bar Association. And it started as a community justice project, as an opportunity for people to resolve their conflicts outside of court. And over the years, CCR has developed so that we work with the public at large, as well as with courts throughout all of Cook County. So we have representatives, mediators in every pro se courthouse in Cook County, as well as at the Daily Center downtown, and at the Daily Center we're there 5 days a week. So CCR mediates about 1,500 different types of cases every year using a large team of volunteer mediators. And we do that in the courthouses, and then we also do mediations at our offices, which are located downtown on Adams near the Art Institute.
Okay. I'd like to remind everyone that this is a live call-in show, so if you have questions, you can call us at 312-738-1060. So you said your services are open. Are they open to anyone in Chicago?
Yes, they're actually open to anyone. Truly, it's not a limitation that you must be a resident of Cook County, and there is no income requirement either. So it's a free service that we provide.
Okay, great. So what exactly is mediation?
Yeah, so mediation is a one-time meeting where the parties are invited to sit down with a neutral third-party mediator and have a conversation about whatever conflict they might be having. So today we're going to talk primarily about landlord-tenant cases, but mediation is used in all different types of cases. We do adult and juvenile misdemeanor cases.
It looks like we have a caller. So, caller, do you have a question?
Yeah, I do. Thank you for taking my question, by the way. I live in a condo unit, and we've been having a lot of internal fights between the condo owners, especially dealing with the condominium association board. So is that something that you guys could help us out with?
Absolutely. We see a lot of condo association cases. It's totally appropriate for mediation. The types of cases that are really great for mediation is when there's a pre-existing relationship before the conflict and when there's going to be a relationship ongoing after the conflict. And so I would encourage you to contact us. We're going to put the number up later, but just so you have it, it's 312-922-6464. You can give us a call, and so long as you have the contact info for the parties that you'd like to attempt mediation with, we actually handle the process from there. We get in touch with all the interested parties and talk to them about mediation and then invite them to come down to our offices. We schedule cases about 3 to 4 weeks out, but something with a condo association is totally appropriate for mediation.
All right, thank you.
Thanks for calling.
Okay, and so the next question I have is, so if someone were to come to you with maybe a condo issue or a landlord-tenant issue, how exactly does mediation work in a broad sense? Like, what are the important things that occur during a mediation?
Right. So what's great about mediation that's different from court, that's just really different from court, is really the role of the mediator. So the mediator isn't a judge or an arbitrator, and they're not going to make a decision for the people involved. Also, the mediator doesn't give legal advice or make any sort of assessment about the legal issues the way that an attorney might. Instead, what the mediator does is helps provide the space and the opportunity for the parties to have a conversation about whatever their conflict might be about. And so what that means is that you end up having an opportunity to talk about a lot of things that might not necessarily be appropriate for court, or that the court might not have the time to hear about. So in an example like a condo association, there are typically a lot of things going on in that type of case. There might be bylaws, there might be different neighbors that have different histories. There's usually a board. And so the mediation would provide an opportunity for those people to talk about all of those different types of things that are having an impact on the parties that are involved. And so that's what can happen in the mediation that can be really helpful in resolving a conflict.
Okay. So it's a lot about talking and communicating through your issues. Is that right?
Absolutely.
Okay.
Absolutely. Mm-hmm. And the mediator's job is to help make sure that everyone has a chance to speak and be heard and understood. And then the mediator's job is also to help the individual parties to think about the conflict that they're having and possible resolutions that they may come up with, and to really talk about and with the other parties about their conflict.
Okay. And so how much time generally do your parties require? How much time is permitted?
So that varies. The cases like the caller had, where I recommended that he call our office and then we would contact the other parties involved. That type of case, we typically tell parties to plan about half a day, somewhere between 2 and 4 hours. And we do those cases Mondays through Thursdays, beginning in the morning or in the afternoon. Like I said, takes about half a day. But we also have a presence in the court system that I was talking about earlier, particularly in eviction court. And those mediations can take between 30 minutes to an hour.
Okay. So at what point would you recommend, we come in contact with tenants all the time, so I'm going to use tenants. So when would you recommend a tenant contact CCR? Or can a conflict be too early or too late?
A conflict really can't be too early or too late. As soon as there begins to be a breakdown in communication is when I would recommend that a party contact CCR. So, because that is the sort of the common denominator that we see in these types of cases, that people end up in court or they end up close to court because there's been a breakdown in communication. Somebody didn't understand what was expected of them, or wasn't able to get a hold of the other party. And so I really don't think that there's a time that's too soon, or even that there's a time that's too late to contact us and to give mediation a try.
Okay. So what steps should a tenant take before they contact?
Yeah, so the only information that we would need the name, address, and phone number of the person that you want to mediate with. And so we would have parties give us a call at 312-922-6464. We're at extension 22. And we will talk about mediation and what to expect, the specifics of the case. And then we'll get the name, address, and phone number of the other parties involved. And then the next step is that we actually send those individuals a letter. And that letter introduces the concept of mediation. It lets them know that the other party has been in touch with us, and that we are offering this free service. We follow that up with a phone call to talk to the party and answer any questions that they might have about mediation. And if they're interested in participating, then what we do is find a time that's going to work for everybody. Like I said, cases scheduled typically about 3 weeks out.
Okay. And what happens if the other party, so the party that contacts you wants a mediation?
Right.
What happens if the other party does not?
Well, even if the parties have talked ahead of time, and you had said earlier a tenant. So if a tenant suggested to their landlord mediation and the landlord wasn't interested, I would actually still recommend that the tenant give us a call, because sometimes just having that third party perspective and being able to answer any questions that the landlord might have about what mediation might look like can often still result in a case. So I would recommend that the party still contact us, and then we would get in touch with the landlord for them and see if they're willing to participate.
Okay. And then if the case is referred to you from the court, is it a requirement that the parties complete a mediation?
I mean, it depends on what the court order says, of course. I don't have any authority to force anyone to participate in a mediation. But that's actually one of the things that makes mediation so valuable, is that it's the voluntariness of the process, that the parties have agreed to take the opportunity and the time to sit down together and resolve their conflict for themselves, rather than having a third party decide what was going to happen for them. So, so it's not a bar to the mediation.
Okay. So how do you think a landlord and a tenant can best take advantage of CCR services?
Well, one great way to take advantage of our services would be to sort of preempt any sort of conflict. And for a landlord and tenant at the beginning of their relationship or early in their relationship, to acknowledge and agree that if there is a conflict, that they'd like to try mediation before going to court, and that they'd like to try CCR. I mean, that's one way that they could do it. Also, really, the best way to take advantage of us is to call when there's a conflict. Like I said, that typically starts as a breakdown in any type of communication, but really, where there's a conflict where the parties feel like they're not understanding each other, or not able to get a hold of each other, usually the opportunity to mediate can be very helpful.
Okay. So can CCR help if an eviction case has already been filed?
Absolutely. Mm-hmm.
Okay. I'd like to remind people that you can call in right now. The call-in number is 312-738-1060. Sorry to interrupt. But
That's
I just
okay.
Want people to
That's
feel
all
free
right.
to call in. So to go back to the question, so if an eviction case has been filed, people can still do a mediation, correct?
Absolutely. As far as we're concerned, people are free to resolve their conflicts however they see fit. And even if parties, if they don't know that mediation is an option before the eviction case has been filed, they can still contact us. And also, there really isn't a time where it's too late. Even in court, the parties could ask the judge if there might be a mediator on site, if there might be an opportunity to mediate. And like I said, at the Daily Center, we're there every morning of the week, Monday through Friday. We have mediators on site that can take cases.
Okay. So how many cases do you handle, I guess, annually?
Annually, the Center for Conflict Resolution annually handles about 3,000 cases. Half of those go through our mortgage foreclosure program, and then the other half are handled by the sort of our general services. Like I was saying earlier, we do a wide variety of cases that are appropriate for mediation. So we see a lot of cases that we call non-court referred. So that's when people just contact us, much like I'd been suggesting earlier. And those are often landlord and tenant disputes, or neighbor disputes, condo associations, roommate disagreements. We also see referrals from different branches of the court, from different types of court cases. And then we also have a presence in civil pro se courtrooms throughout Cook County. So that's when an individual is suing another person or a corporation, but they're representing themselves in court.
Okay. And so if someone isn't representing themselves, they have an attorney, can their attorney be present at the mediation?
Absolutely.
Okay.
Absolutely. Mm-hmm.
Okay. So I guess that brings me to my next question. What role does the law or the rules? So, tenants in Chicago their rights, a lot of them are established under the Chicago Residential Landlord and Tenant Ordinance. What role would that play in a mediation between a landlord and a tenant?
So as I said earlier, the mediator isn't going to serve as a judge or an attorney. So the mediator isn't going to give any legal advice. And so the role that the law might play for them is determined by the parties. A lot of the time, even if the statute says something, it might not necessarily be the thing that the parties want to do. So, you might have a case where, depending on what had happened, the law would say this tenant is going to be evicted. But it might turn out, when the landlord and tenant sit down together, that the tenant would like to stay and the landlord would like them to stay. Mm-hmm. And mediation would give the parties an opportunity to figure out if that's a possibility and how they'd like to do that moving forward. So the law is only present in the mediation as much as the parties rely on it and want to discuss it. But it's not the mediator's job to inform parties of the law. or to discuss the law with them necessarily.
Okay. And is that part of what also makes you a neutral party in this whole thing?
Yes, yeah. Not giving legal advice, not giving any type of advice, is one of the things that makes the mediator neutral. Another part of the mediator's neutrality is that the mediator isn't interested in forcing the parties to come up with an agreement. So the mediator doesn't have an agreement planned that they want the parties to agree to, nor will the mediator suggest one during the course of the mediation. Instead, the mediator's job is to help make sure that the parties are able to have that productive conversation, as well as if the parties do come up with a resolution that's going to work for them, the mediator's job is to help talk to the parties about feasibility, make sure they've really thought through all the elements of the agreement, and then to write that up for them.
Okay. And so I guess what happens at the end is that the agreement is written up for the tenants. Can you elaborate on that?
Right. So if the parties choose to come to an agreement, which is totally up to them, but if the parties do come up with a resolution that's going to work for both of them, then that's a document that the mediator can write up, and then that's a document that everyone would sign, and everyone leaves with a copy of it.
Okay. So if a tenant comes to you and they have a major repair problem in their building, how would that process work for the tenant?
So, if the tenant called and said, this is the problem that we're having, I would say, I need your landlord's name, address, and phone number. And then I would send the landlord a letter. And that letter would say, this tenant has contacted us about a conflict that the two of you might share, and they'd like to try mediation as a way to resolve it. And then the letter would ask the landlord to call. Then once we had an opportunity to speak with the landlord, we would talk to the landlord about what mediation might look like, answer any questions the landlord might have about the process, and then we'd offer an opportunity for the landlord and the tenant, and anyone else that the two parties agreed should be involved, to come down to our offices downtown and meet with the mediator to discuss the conflict.
Okay. And do you have any general tips for tenants and landlords about avoiding or de-escalating conflicts?
Well, I would say that the majority of mediations, that what we see, the reason that people have ended up in the type of conflict that results in them being in court, is that there's been a breakdown in communication, that parties haven't been able to get a hold of each other, or they haven't been returning calls, and just keep maintaining open lines of communication, even if that communication is uncomfortable, even if that isn't easy, is usually would be my best piece of advice for parties who might end up either in court or in mediation.
Okay. And so a lot of times we get clients where we advise them that it's really important to document what's happening, if they have repair issues. How important is documentation in the conflict resolution?
Actually, from the mediator's perspective, it's not necessary at all. The mediator isn't going to review any of the evidence or look at it. What's important is for the party to bring in anything that they think might help them in telling their story. So if the tenant wants to be able to communicate something about the apartment to the landlord and the landlord hasn't seen it, then perhaps documentation might be helpful. But that's not something that we would ever require of the parties.
Okay. So I'd like to remind everyone that you can still call in. Our phone number is 312-738-1060. So do you have any other general advice about, mediating landlord-tenant issues?
Sort of general. No. I would say, in general, in a mediation, if you do end up in a mediation, if you find yourself in a mediation, which could very well happen, you might be planning to go to court and the judge might send you to mediation, to really see it as an opportunity. One of the things that's really great about mediation is that it provides an opportunity for parties to sort of figure out their conflict for themselves. And individuals really are best suited to come up with their own resolutions for conflicts that they might be having. And so if you do end up in a mediation, I would recommend that you participate fully and really see it as an opportunity to tell your side of the story and to figure out what has happened and to come up with a resolution that's going to work for you and make sense for you.
So at the end of the it's not arbitration, but at the end of the mediation, you have an agreement, and say the landlord doesn't keep his end of the bargain. What do you advise tenants to do in that situation?
Well, for whenever we call that a breach. So when somebody breaches the agreement, the first thing that we recommend you do actually is call us. Our phone number appears at the bottom of the agreement, and we recommend that the first thing a party do when there's been a breach is contact us. And what we'll do is call the other side and see if something's happened. Did the check go out yesterday, or does it turn out that somebody had the wrong address or something like that? Another one of those communication breakdowns may have occurred. And so we, we'll contact the other side and see if there's an answer to a question or a way to communicate. In the alternative, if the case has come from court and the parties have come up with an agreement that didn't end up working for them, they're free to return to the same court. It's not a bar to accessing the court system to take advantage of mediation.
Okay, so it looks like we are short on time, but I would just like to say, of course, thank you to Ray, but I want to tell you about our upcoming episodes and hope that you tune in. November 1st, Keep Chicago Renting Ordinance with Albany Park Neighborhood Council. November 8th, Building Conditions and Utility Shutoffs with the MTO, the Metropolitan Tenants Organization. Healthy Homes the following week with MTO as well. There's a rental housing expo tomorrow, 9 a.m. to 2 p.m. at Loyola University. And we are the Lawyers Committee for Better Housing, located at 33 North LaSalle. You can reach us at 312-347-7600. Our website is located at www.lcbh.org. Ray, courtesy was very great to have you, and thank you for answering all of our questions.
Yeah, thank you for having me. It was great to be here. And if you have any questions about mediation or you think you might have an appropriate case, please feel free to call us, 312-922-6464, extension 22.
Okay. Thank you so very much. Please stay tuned for the next show and come back next week to watch the Lawyers Committee for Better Housing.